Constitution of India brought in a new era in our lives. So the Constitution of India ushered in a new era for the citizens of this country and for other people residing here. I say a new era, but I mean an era of freedom. एक आजादी हिंदुस्तानियों को मिली जब कॉन्स्टिट्यूशन आया हमारे देश में, जब कॉन्स्टिट्यूएंट असेंबली ने कॉन्स्टिट्यूशन बनाया. And what was a very important chapter in the Constitution was the fundamental rights chapter of the Constitution. Now we have to understand one thing. The Constitution lays down the broad guidelines. It lays down the principle. It lays down the crux of what are the kind of laws that are going to be the with which all laws in the territory of India should be aligned with, should be in tandem with. And that is what we have to understand. It lays down broad principle. It doesn't spell out women's rights like that. But what it does do, it lays down that women, that every citizen, for instance, shall have a right to do certain things. And the women's rights, particularly from the equality article in Article 14, states that everybody shall have equal protection before the law and everybody shall be equal in our country. So equal protection of laws and equality before the law. This is what Article 14 of our Constitution states. And from that, we have to garner that women and men have equal rights, that all citizens should be treated equally, whether they belong to different class or different castes or a marginalized group or are women. So these are the sort of principles that the Constitution lays down. And a very important fact is that once in Article 12 of the Constitution and Article 13 particularly, what the Constitution of India states is that all laws which are in derogation of Article of the Fundamental Rights Chapter of the Constitution, or which in any way violate the Fundamental Rights Chapter of the Constitution, or will be void to the extent of the inconsistency. So once the Constitution came into place, the laws which existed, insofar as they were void with the provisions of the fundamental rights and insofar as they might be void of the provisions of the Constitution would be void. Have we come to this? Because I wanted to lay down the context first. पहले हमें समझना पड़ेगा क्या ढांचा है संविधान का. ये ढांचा है जो हम लोगों को इस जब कॉन्स्टिट्यूशन आया, जब संविधान आया, तो हम लोग को पहली बार एक तरह की आजादी मिली, डेमोक्रेसी आई हमारी कंट्री में। हमारी कंट्री में हमें ये आजादी मिली कि अब हम सिर्फ उन कानूनों से गवर्न होंगे, वही कानून हमें गवर्न करेंगे जो कुछ प्रिंसिपल्स जो कॉन्स्टिट्यूशन में हैं उससे मिलते जुलते हो। सिर्फ मिलते जुलते नहीं, उन प्रिंसिपल के तहत सारे कानून होने पड़ेंगे। तो ये बहुत एक जरूरी बात है, आपको समझनी पड़ेगी कि कॉन्स्टिट्यूशन प्रिंसिपल्स ले डाउन करता है और कॉन्स्टिट्यूशन कहता है कि जो भी कानून बनेगा हिंदुस्तान में उसमें कॉन्स्टिट्यूशनल प्रिंसिपल्स फॉलो करेंगे जो कानून बनाने वाले हैं, पार्लियामेंट जो है। अगर नहीं फॉलो करेंगे तो उसका असर ये होगा कि उनको वॉइड डिक्लेयर कर सकते हैं सुप्रीम कोर्ट और हाई कोर्ट। वो जस्टिसेबल है। These principles in the fundamental rights chapter, if they are violated, are justiciable and can be struck down by the High Court and by the Supreme Court under Article 226 and Article 32 of the Constitution. So this is one of the most important things that we must remember in the context. Now, what are these articles? These are Article 14, Article 15, Article 16, Article 19, Article 21, which lays down, and so on, which lays down certain fundamental freedoms. And all our cases have been decided on the basis of that. Article 14 talks of equality, as I said. Article 14 जो है वो समानता की बात करता है और हर कानून को जो औरतों के तहत बना है या नहीं बना है तो उसमें औरतों की समानता होनी चाहिए। वो पेट्रियार्कल नहीं हो सकता, वो ऐसा नहीं हो सकता कि वो डिफरेंट पे दे औरतों को और डिफरेंट पे दे। एक स्कूल जैसे है, डिफरेंट पे स्केल रखे औरतों के लिए और डिफरेंट पे स्केल रखे आदमियों के लिए, और मेल टीचर्स एंड फीमेल टीचर्स। और कॉन्स्टिट्यूशनल प्रिंसिपल्स के ही because of that you have the Equal Remuneration Act in 1976. So, giving equal pay for equal work, for the same work, for the work of the same value actually. And that is why, because of this equality clause, that we have to have a democratic setup in our country. And that is very important. Democracy is even more important for women than it is maybe for certain classes of people, because women suffer immensely when democracy is not there. When democracy is at stake, then who is it who will be attacked? Women. And when I say when democracy is at stake, if for instance women are not considered equal in the household, then what will happen? If for instance women are not considered equal at the workplace, what will happen? So it is this constitution and that breathes life into the whole concept of equality, that specifies equality. In the household, we have certain laws which protect women against violence. Because what violence does is, violence undermines equality. Violence undermines the dignity of women, which is given to women, which is interpreted as a part of Article 21. So if there is violence, it undermines the functioning of women. And if the functioning of women is undermined, then women cannot function at power. That is why you have laws for women in the household and which try to enforce the equality principle. We have a long way to go in our country. हमें बहुत दूर जाना है इक्वालिटी लाने के लिए, स्पेशली घर में. पर घर में भी इक्वालिटी जो कुछ भी है वो इसी वजह से है कि हम एक डेमोक्रेटिक सोसाइटी में रहते हैं. हमारे ऊपर एक कॉन्स्टिट्यूशन है जो कहता है कि हमें कुछ हक होने चाहिए जो हम लोगों को डिग्निटी के साथ ट्रीट करें, जो हम लोगों को इक्वालिटी के साथ ट्रीट करें घर में. और इसीलिए आपके लॉज हैं, डोमेस्टिक वायलेंस एक्ट है आपका लॉ है, मेंटेनेंस का लॉ है आपका, और भी कानून है. आपको हक है मांगने का, सेपरेशन और डिवोर्स एक्सेट्रा घर में, जहाँ तक घर का सवाल है. और हमने इंडवा की तरफ से और भी कानून मांगे हैं कि हम कहते हैं अगर औरत और आदमी एक जैसे हैं, उनका वर्थ, चाहे वो घर का काम करे, चाहे वो घर का काम नहीं करे, चाहे वो बाहर का काम करे, फिर भी वो जब, क्योंकि बच्चे को देखभाल करती है, क्योंकि बूढ़ों को देखभाल करती है, because she takes care of the young and the old, a woman should have an equal right to marital property. उसका क्या मतलब है? उसका मतलब ये है कि उसके जो हक है, जो भी कुछ घर में आ रहा है, जो भी कुछ घर में खरीदा गया है, उसका उतना ही हक बनता है जितना हक बनता है अगर वो काम भी नहीं करती है तो जितना उसके हस्बैंड को बनता है. और ये कानून हमने मांग रखा है और ये काफी 144 देशों से ज्यादा देशों में ये कानून है. This right to marital property act on the basis of a woman's contribution to household work, on the basis of a woman's contribution to looking after the children and the older people in the household. This contribution is equivalent to what a husband can bring in. And strangely enough, हाल ही में there was a decision of the Madras High Court in which the Honorable Judge recognized this principle as in tune with the concept of equality in the Constitution. So a Madras judgment recognized this, that a woman's worth is equivalent to whatever is brought into the house by the other working partner. So, whether in the house, I said, or whether outside the house, a woman has a right to equality. But this is not at all in tune with what is happening right now. Because what is happening right now, it is Manusmriti which is being followed. There is an attack on our constitutional principles of equality, particularly of dignity for women. Because I will go into the whole concept of dignity and what it is meant for women. But let me talk a bit about the Manusmriti and what it does. The Manusmriti sees women as an unequal partner in the household. It sees women as something less, something secondary to the man. It sees women's role as something confined to the household. And because it considers that a woman is a lesser human being than a man is, it actually says that if she commits any wrong, it is all right to even beat her. Or to give her a slap or two. This is what the prevailing philosophy about women's rights is, unfortunately, even within the ruling party in India. So we have to sharply distinguish between the rights that a woman has got hitherto in law, in other laws, in Hindu laws, and the rights that she has under the constitution. तो हम लोगों को बहुत बहुत समझना पड़ेगा कि मनुस्मृति क्या है, वो क्या देती है और हक औरतों को, और कॉन्स्टिट्यूशन क्या देता है. क्योंकि मनुस्मृति तो ये सोचती है कि वो दूसरे दर्जे की है, उसको घर में रहना चाहिए, उसको एक अच्छी माँ बनना चाहिए, उसको एक अच्छी घरवाली बनना चाहिए, उसको खाना पकाना चाहिए और ये सब, और फिर भी उसको वही दर्जा नहीं देती जो आदमी को देती है, घर के आदमी को. वो कहती है कि या जस्ट गिव मी द वाटर प्लीज, थैंक यू. वो कहती, मनुस्मृति कहती है कि आदमी और औरत एक जैसे नहीं हैं. वो कहती है एक कास्ट का आदमी और एक कास्ट की औरत और दूसरे कास्ट की औरत एक जैसी नहीं है. मनुस्मृति में बहुत शार्प डिस्टिंक्शन है कि कास्ट क्या होता है. उसमें ये है कि ये कास्ट सिस्टम को मेंटेन करना चाहिए, और उसमें ये भी है कि ये औरतों का दूसरा दर्जा मेंटेन करना चाहिए. तो इसीलिए हमें बहुत स्पष्टता से खिलाफ है. The Manusmriti is totally against the constitution, and particularly what we call constitution morality, which is a morality based on the constitutional principles of equality, of living with dignity. So I spoke to you only of articles of equality, which of course, if that is violated in any law, then we can take it up to the court. And it has come up in a number of cases. And equality क्या होती है? Equality is not only the sameness, but equality is substantive equality. कॉन्सेप्ट जो है इक्वालिटी का वो ये कहता है कि आप जो हैं, आप सिर्फ अगर आप ऑलरेडी फंक्शन कर रहे हैं नीचे दर्जे में, सब्सटैंटिव इक्वालिटी वो होती है, द सब्सटैंटिव इक्वालिटी कॉल्स फॉर redressal of those wrongs. It states particularly, and a Kerala High Court judgment states it beautifully. I don't have the time to read it here, but I will say that substantive equality means a redressal of the wrongs historically suffered by women as a marginalized section. The law recognizes that women have suffered by not being treated as equal, but it says, therefore, that unless you redress the wrong, you cannot treat women equally with men. You can't say that you both have the same rights and the same thing because women are not at that level. They've been treated in a such similarly. You can't say that you treat a person, a Brahmin, like you treat a non-Brahmin. And that is, or a scheduled caste or scheduled tribe person. Because that is an inequality which has been inherent in our system for ages. And to do away with that, the Constitution comes into play. So, in Article 15 of the Constitution, it clearly says that nobody can be discriminated on the basis of caste, religion, sex, and so on. So nobody can be discriminated, and it gives the state specific powers to make provisions to redress the discrimination. That is why you have acts like the anti-sati legislation to redress the discrimination. That is why you have reservation, particularly reservation in education, which will concern you all. The act of reservation is not seen as an act which is spreading the discrimination further, but it is a positive. Some people have called it a positive discrimination. It's a positive provision in any case to redress the discrimination. Because if somebody has suffered for ages as on the basis of their caste, then obviously you will give them more space in an educational institution. You give them to enter into enter into the education system and to be a part of it. And hence, reservation in India has been there since the beginning of our constitution. I'm sorry, I'll just. Just. So that's Article 15 is what is called the non-discrimination article. So we have a positive article, we have an article which says you can't discriminate, and we have an article which says that you can make special provisions. So reservation is making special provisions. All laws for women are making special provisions for them. Before I go on to actually discuss the laws, I also want to say this, that apart from Article 15, we have Article 16. And what does Article 16 say? And remember, these are broad principles. And the state is supposed to make laws under these principles. A lot of people don't know that. It's not the Constitution which spells out the laws. It gives you guidelines. It says laws must be in conformity with these guidelines. And this is something you have to understand. I think every one of us should have a copy of the Constitution of India so that we actually know what the Constitution is. Then Article 16 says that there should be equal opportunity in employment and there should be no discrimination. Then a very important article is Article 21. So Article 21 says that everybody has a right to life. Nobody is right to life
It's called the right to life article. As it says, no person shall be deprived of his right to life except through due process of law. So, what it means is this, that everybody has a right to live. And when you say everybody has a right to live, you don't mean a mere animal existence. You mean a right to live with dignity. Just tell me how much time I had. Am I all right with time? Huh? So everybody has a right to live with dignity, and everybody has a right to a humane condition of living. Everybody, even in the jail, you can't be tortured. Even in the jail, you have to have certain facilities, which in our jails perhaps we are not giving. Even so, you cannot be tortured, you cannot be forced to give confessions, you have to have proper sanitary conditions of living in a school. And of course, we have the Right to Education Act, which specifies that. But in a school, there should be the right to life also informs that. Because it just doesn't mean the right to life, it means the right to live with dignity in a situation. It has also been interpreted to mean the right to live with uh, dignity and the right to privacy of a human being. So, first of all, I'd just like to say that the right to live will take into consideration, for instance, the right to live or right to work in an environment which is a sanitary environment, in which women's, for instance, in schools, in which women are provided all the facilities, in which girls have facilities, proper bathrooms, and this is provided in the Right to Education Act also, but it's from the right to life that you get these very important rights to living as a human being ought to. So, proper sanitary facilities, proper bathrooms, proper creches for teachers, proper um breaks for all the school teachers when they need to nurse, and a number of other whole host of rights also. So these are the rights which are important. I will do that. These are the rights which are important uh, for all of us. So I will do it in a little later. Similarly, what is another right that all school teachers, women school, that all women have in the place where they work? That is a right to be free of sexual harassment, of right to be free of sexual harassment, and a right to, and what is that is why in the Vishakha case, if you remember, the Supreme Court traced out this right. We didn't have a law of sexual harassment at work. So women were not only teased, they were misbehaved with, they were molested sometimes, and other sexual attacks were made on them, and they couldn't do anything. But then came the Vishakha judgment, and it said, no, how can you have an absence of law in something that is so pervasive, समथिंग जो हर रोज होता है एक जगह पे, आप कैसे कानून नहीं हो सकता उस पे? क्योंकि अगर आपका नहीं कानून है तो इसका मतलब है कि आप औरतों को सफर करने दे रहे हैं, सफर करने दे रहे हैं, और आप औरतों को के लिए कुछ रेमेडी नहीं दे रहे. So therefore in Vishaka a set of guidelines were made to tackle sexual harassment, and therefore I hope in all your schools you have sexual harassment committees. That is a must, because sexual harassment can be very egregious. सेक्सुअल हरेसमेंट एक बहुत खराब चीज भी हो सकती है जो एक औरत को फंक्शन नहीं करने देती. वो औरतों को बिल्कुल विदाउट रेमेडी औरत सफर करती रहती है. कभी कभी कोई उनके साथ अगर मिसबिहेव करता है तो उसके बारे में कुछ नहीं कर सकती. तो इसीलिए सुप्रीम कोर्ट ने कहा कि प्लीज सब sexual harassment committees, and this is one of the things that you all can pick up. Secondly, I will talk of two more topics. I have been requested to speak on the Uniform Civil Code, which I will come by as a last topic. But before that, I want to talk about maternity benefits, which are one of your demands. And we had, it is because of the special provisions which Article 15 allows that we can have maternity benefits also. And at the moment, in the law, we have 26 weeks which people can take as maternity benefit. And there's a judgment again, this time of the Delhi High Court, which has talked of why it should be available both to a person who is a temporary teacher, a daily wager, and it should be available to the as it should be available to the permanent teachers. The judgment explains a bit about constitutional philosophy and this thing. And I would just like to read a paragraph of the judgment. It says that a just social order can be achieved only when inequalities are obliterated and everyone is provided what is legally due. Women, who constitute almost half the segment of our society, have to be honored and treated with dignity at places where they work to earn their livelihood. Whatever be the nature of their duties, their avocation, and the place where they work, they must be provided all the facilities to which they are entitled. This patti, to become a mother is a most natural phenomena, because this was in the a case for maternity benefit in the life of a woman. It's a natural phenomena. Um, Whether it is needed to facilitate, whatever is needed to facilitate the birth of child to a woman who is in service, the employer has to be considerate and sympathetic towards her and must realize the physical difficulties, etc. The Maternity Benefit Act aims to provide all these facilities to a working woman in a dignified manner, so that she can overcome the state of motherhood honorably, peaceably, undeterred by the fear of being victimized or forced absence during pre or post natal period. So the whole philosophy of the Constitution, in one sense, is that she, a woman should be in our society, and what we call constitutional morality. is that a woman in our society must not suffer from violence in any form, mental or physical, that she must be able to conduct her life at this equally, as an equal with the rest of the society, as an equal with men, that she must live a life of dignity, and that she must be able to dream and aspire to whatever she wants. And here I must talk to you about a phenomena which is very common, especially in the state of Haryana. I'm afraid I'm speaking too much in English, huh? ठीक है. Uh, which is very common, and that is the whole, uh, I would say, concept of honor, crimes, and killings in the name of honor. This is a phenomena which completely, which seeks, phenomena which occurs in a lot of North Indian states, and not only North India, but in states like Tamil Nadu, where not only panchayats, like the Katta panchayats and all, try to stop marriages between an upper caste and a lower caste person, or within, outside the same, within the same gotra, or other marriages which are legally allowed by our law. And the Supreme Court has repeatedly, in quite a few of its judgments, held that is this cannot be done. You can't stop a young boy and a young girl from marrying who they want. In fact, I remember Justice Karju said, you may agree with it or you may disagree with it. It doesn't matter. But you can't commit an illegality, you can't commit acts of violence on young people because they want to marry each other, or because they want to be together, or be in a relationship. Because the Supreme Court said, and particularly in the privacy judgment, it says every human being has a right to choose how to live, whom they should live with, where they should live. This is a free country. And once you're over age, 18 of age, if you can vote, you can choose your partner. And parents may disagree. Parents often disagree. But that doesn't mean you can kill people because of that, or kill the man, or ostracize them, or commit all kinds of social atrocities towards them. And Edwa again has brought a law on honor killing, which we must, there's no time to talk about it, but this is a law which we must ask for, especially from a woman's perspective. Because if she doesn't have the choice at that time in her life to even choose her partner, she can be, her choice can be undermined, then she's in for a lot of unhappiness through her life. Anyway, so that is one other topic. And lastly, I would like to speak about uh, this whole, what is it that we want as laws which give equality to women? We want laws which give equality to women, and we talked of some of these laws. We want laws which, for instance, make women an equal guardian of her child. Because right now, that in Hindu law, a woman is not an equal guardian. In Under the Hindu adoption and maintenance laws, as well as the Hindu Guardianship and Wards Act, a woman is only can have the custody of the child till the child is 5, and she can be the, but she is not the natural guardian. So at least these are basic inequalities which must go, because strangely, ironically enough, it is the woman who is taking care of the child, and yet she doesn't have the power to make decisions over them. Though, of course, the courts have dealt with this in a sympathetic manner as far as women are concerned. However, if we want equal in our country, what has been happening since independence and a few laws before that also is that we have common laws which apply to all women. For instance, the Anti-Sati Act, the Dowry Prohibition Act, all the criminal laws, and so on. The Protection of Women Against Domestic Violence Act being a law uh, which came about in recently, the anti-sexual harassment legislation. So we have a set of common legislations, even section 125 of the CRPC. हमारे देश में कॉमन लॉज हैं जो औरतों के लिए बहुत औरतों के लिए पास करे गए थे, उनके प्रोटेक्शन के लिए पास करे गए थे, उनके राइट्स, उनके हकों के लिए पास करे गए थे। और ये लॉज, बहुत सारे लॉज हैं, हमने आपको बताया, सती के खिलाफ, दहेज के खिलाफ, सेक्सुअल हैरेसमेंट के खिलाफ, डोमेस्टिक वायलेंस के खिलाफ, ये सब लॉज हैं। और उसके अलावा हमारे पास दूसरे जो लॉज हैं, जो पर्सनल लॉज हैं, वो अलग अलग हैं, अलग अलग हैं। मतलब हिंदुओं के दूसरे हैं, क्रिश्चियंस के दूसरे हैं, मुस्लिम्स के दूसरे हैं, पारसीस के दूसरे हैं। तो बहुत चर्चा हाल में हुई थी कि भाई हमारे एक कॉमन सिविल कोड होनी चाहिए। चर्चा ये हुई थी कि इंडियन शुड बी गवर्न्ड by a common civil code for the sake of uniformity. And the Prime Minister, in fact, made an analogy, said in the same house, you cannot have people doing two different things. I don't know what he meant by that, because the analogy is not very good. In India is a very diverse country. हिंदुस्तान एक बहुत बड़े देश है, बहुत बड़ा देश है, उसमें तरह तरह के लोग हैं, तरह तरह के हैबिट्स हैं, और आप ये नहीं कह सकते कि ये एक साथ नहीं जुड़ के रह सकते हैं। तो जैसे कि एक और संस्थाएं थी औरतों की, उन्होंने कहा ऐसी बात है कि हमें कोई भरोसा नहीं है इस गवर्नमेंट पे कि वो सचमुच समानता के कानून लाए, कि that this government will bring in laws which are for equality for women, which give women equal rights, because they essentially believe in the Manusmriti. They believe in a non-constitutional philosophy. So how is it that the laws which are uniform will bring equality for women? And we have also seen how bad their track record is. Their track record is what? Their track record is that they haven't brought even a single law which will ameliorate the condition of women. Which एक भी कानून नहीं आया है 2014 के बाद जो औरतों के हक देता है, औरतों को हक, उस हक बढ़ाता है। कौन सा जहां जहां औरतों की संस्थाओं ने कानून मांगे थे कि औरतों को समानता का हक मिले, वो नहीं दिए गए हैं। जैसे मैंने बताया, गार्डियनशिप एक्ट के अंदर भी उनको इक्वल गार्डियन भी नहीं बनाया अपने बच्चों का। सरकार ने ये भी नहीं दिया कि औरतों को वही हक को घरेलू चीजों के ऊपर, प्रॉपर्टी के ऊपर जो आदमियों के पास है। आप जानते हैं कितने सारे स्टेट हैं हमारे कंट्री में। 2005 को हिंदू सक्सेशन एक्ट में बदलाव आई थी, और वो क्या था? वो ये था कि अब जो सक्सेशन एक्ट है वो नहीं सेव करेगा कोई भी एग्रीकल्चरल कानून को। और हमें याद है डिस्कशंस में हम लोगों ने कहा था कि औरतों का इफ यू को इक्वल हक मिलना चाहिए लैंड में। तो हम उस वक्त भी लोगों ने कहा, आप कौन सा मतलब क्या ड्रीम कर रही हैं? हाँ, क्या ड्रीम कर रहे हैं आप कि औरतों को इक्वल हक कभी नहीं लैंड में मिलेगा? और वो सही है। बहुत सारे कानून हैं जिसमें औरतों को इक्वल हक नहीं है। अरे भाई, हिंदू सक्सेशन एक्ट में भी एक वो है, एक सेक्शन है जो औरतों की जायदाद एक दूसरे तरीके से डिस्ट्रीब्यूशन होता है उसका, आदमियों की जायदाद दूसरी होती है। औरतों की जो जायदाद है उसमें हक, अगर उसका कोई बच्चा या हस्बैंड ना हो तो पहले जाता है हस्बैंड के एज पे, और फिर आता है उन उसके मत। तो एक एक केस आया था, आई एम टॉकिंग अबाउट द केस अंडर द हिंदू सक्सेशन एक्ट, इन विच व्हाट हैपेंड वाज दैट अ वुमन, एक औरत जिसकी बिल्कुल मतलब उसको निकाल दिया गया था अपने ससुराल से, उसका हस्बैंड मर गया था, उसका कोई बच्चा नहीं था, तो वो निकल के अपने माँ बाप के पास रही, और उसने वहाँ पे कमा के या जो कुछ भी है, कुछ उसके पास कुछ पैसे वैसे बने, एसेट्स हुए। जब वो बरी तो ये केस गया सुप्रीम तक, क्योंकि उसके माँ बाप ने कहा कि ये तो हमारे पास आना चाहिए। पर उन्होंने कहा, सुप्रीम कोर्ट ने, ये तो आप सही बात कर रहे हैं कि आपके पास आना चाहिए, पर आपके पास नहीं आ सकता, क्योंकि हमारा कानून ये है। हमारा कानून जो है सेक्शन 15 हिंदू सक्सेशन एक्ट है, वो ये कहता है कि अगर एक औरत का आदमी और बच्चा ना हो तो उसकी सारी जायदाद उसके आदमी के मदर फादर को जाएगी। सो देर इज अ क्लियर पेट्रियार्कल बायस, ये बिल्कुल एक बायस है। पर ऐसे ऐसे कानून बहुत सारे हैं हमारे। वी हैव अ लॉट ऑफ successive governments, perhaps you can even say. Certainly this one has not given rights to women. So how do we know what they are talking about when they talk of uniform civil code? And certainly a person can decide whether to get different ways of getting married. They have different customs, and this uniformity is therefore not the most desirable thing. For instance, in a Muslim marriage, there is this whole custom of the man declaring what meher he will give. Maybe it won't go to the woman, maybe practically, but it is a thing which is not bad. You can't say get rid of that custom by having other uniform laws. So we feel that the whole idea of a uniform civil code is a bogus idea. And women's organizations are not interested in just having uniformity without equality. No uniformity without equality is the call that we must have. I can go on and on speaking, but maybe I should, wind up. I just want you to know that the Constitution has a thing saying that the state can work towards a uniform civil code. But why is it in only a directive principle? It's it's not a fundamental right, because there were very many difficulties which were realized at the time also, that it's not a feasible idea. And you have to take along, when you're going to make a law, you have to take along people from different communities, make them agree. You have to. So this, unless that is done, a uniform civil code is only an idea to divert the attention of people from on certain issues, because actually you're not giving anything further to women, but you are saying that there should be uniformity. So with this I'll conclude, except that our constitution tries to establish a just and humane order and equality for women, and we shouldn't, and it's important to support the constitution, particularly at this juncture when it is in danger, when all kinds of ideas, retrogressive ideas, are coming up to undo constitutional morality, and to say that some morality from a particular community, which is there in certain texts, should prevail over the constitution. Thank you.
Comrades, in our country,